Happy day and a very warm welcome to today's session. Today's session is about the Child Labour Prohibition and Regulation Act of 1986. In today's topic, we will be covering a few important provisions and the main outline of the entire Act. The learning objectives will be covered, the object of the Act, the scope of the Act, some very important definitions, some important provisions of the Act, the working conditions of children, the maintenance of registers, the penalties for non-compliance with provisions of the Act are some of the details that we will be covering under this in today's session. Moving on to the learning objectives, like all of us are aware, there have been a lot of violation on the rights, on a range of rights that are available to children. Children have been denied the privileges to which they are entitled to, including the privilege of education, not only in India but all over the world, as we will be looking at later point of time when we try to gain more perspective on this topic. What has the Act done? What have all the countries, nations of the world done in order to grant these rights and privileges to children? So to bring that into perspective, we will try to study the main provisions of the Child Labour Prohibition and Regulation Act of 1986. In India, the constitution of the country has given three main articles, Articles 21A, Article 24 and 39, Clause E and F, which we will be looking at a little bit while we proceed a little bit into the sessions. And in order to understand the legal framework of the entire Act, let us start off by looking at the objects of the Act and the scope of the Act. The object of the Act says that, as defined under Section 3 of the Act, prohibits employment of children in certain hazardous occupations and hazardous processes, and tries to regulate the working conditions of children in all other occupations and processes. This Act is applicable throughout India to all the states, all the union territories in India. Now let us look at the important definitions in the Act. Some of the important definitions that we will be covering in today's session will include appropriate government, any establishment that is controlled by the central government, including the railways, ports, oil fields and mines. To all of these establishments, the appropriate government will be the central government. To all the other establishments, other than the ones mentioned above, the appropriate government will be the state government. The second important definition that we have to look at is who is a child. A child is a person who has not completed 14 years of age, and a day as per the definition of the Act will include a period of 24 hours beginning at midnight. And trying to define the term establishment, it includes a lot of establishments, a lot of organizations which include shops, establishments, restaurants, eating places. It includes a range of theaters and other places of public amusements and entertainments. Moving on to the definition of an occupier, any person who has ultimate control over the affairs of the establishment or the workshop is called as an occupier. And a workshop is a place or a premises, including the prisons, where any industrial activity is going on. It does not, however, include premises which has been defined under Section 67 of the Factories Act. While we all know that these acts are in place, what is the real scenario? The real scenario is judged based on, or we can conclude about the real scenario based on a few judiciary rulings that have been highlighted in this particular Act for the purpose of understanding the provisions of this Act. So the role of the judiciary as far as we are concerned in this particular section, will talk about Article 24, which prohibits employment of children under the age of 14. Article 21A, which states that every state must compulsorily provide education to all children. And Article 39, Clause E and F says that every state has the responsibility to safeguard the interest of the children and to try and provide them education. So let us look at some of the Supreme Court rulings. In the case People's Union for Democratic Rights versus Union of India, the Supreme Court held that there was a gross violation of Article 24, and it also laid emphasis that fundamental rights of the children should not be denied and that children should not be forced into child labor. In the case Bandhwa Mukti Morcha versus Union of India and others, where the Supreme Court held the ruling on children working in carpet making industry in Mirzapur, UP state, 144 children were released from forced labor by the order of the Supreme Court. In the case Sheila Basre and others versus Union of India, the Supreme Court gave directions stating that children should not be employed in processes which are hazardous. Like example, like how it happened in this case where children were exposed to chemical fumes and dust and coal dust from furnaces while they were working near glass industries. And in the landmark case of M.C. Mehta versus State of Tamil Nadu, the Supreme Court held that children should not be allowed or forced into child labor, and where a child is withdrawn from child labor, any one adult person of the family must be replaced by the child and must be given employment in that particular establishment. Let us move over to the provisions in relation to regulation of working condition of children. So these were some of the important rulings that were made by the Supreme Court. So all these go to show that despite the act being in place, despite children being asked to go for education, pursue education, there are cases where children, by virtue of their economic conditions, are forced to go into labor. So what is the Act going to do for this? While the Act has prohibited children from entering into employment in certain cases, into certain types of employments, hazardous occupations and hazardous processes, it tries to understand that it becomes absolutely essential for a child to work at some point of time by virtue of his or her economic condition. Therefore, the Act has made certain regulatory conditions in case where a child is compulsorily, by virtue of their economic position, required to work in order to maintain the important provisions. Section 3, the most important underlining provision, prohibits employment of children from working in hazardous processes or any hazardous occupations. There are 16 hazardous occupations as set forth in Part A of the schedule and 65 hazardous occupations processes which are set forth in Part B of the schedule. No child can ever be employed in any of the occupations or processes which have been set forth in Part A or Part B of the schedule. That is strictly prohibited. In case of all the other occupations, what are the rules or what does the Act do in order to safeguard the interest of the child? They have brought in some regulatory measures. So Part 3 of the Act talks about those regulatory measures which are applicable to children who are forced into employment either by virtue of their economic condition or because their parents or the society requires them to work in order to keep up their own sustenance. Let us look at some of the important sections. Section 7, which talks of hours and period of work. Section 8, which talks of weekly holidays. And Section 9, which talks of notice that can be given to inspectors. Section 7 says that no child can be allowed to work for more than 3 hours in a day. And at the end of the 3-hour period, the child must compulsorily receive a 1-hour interval or a break from the work. And the child can proceed to work for the next period of 2 hours, but at no point of time can a child be required to work for more than 6 hours on any working day. The other provisions as stipulated under Section 7 state that no child should be permitted to work any time between 7 p.m. to 8 a.m., which means a child cannot work or should not be allowed to work on a night shift. And no child will be permitted to work overtime, and no child will be permitted to work in any 2 factories at the same point of time on different shifts, which means on any one day a child is allowed to work only in one establishment. Section 9 states that every employer who permits a child to work must also serve a notice to the inspector within 30 days of employment of the child, stating, giving a few details. For example, the notice must be a handwritten notice. It should be sent across to the inspector, and it should contain details about the nature of the establishment, the nature of work that the child is given, the name of the child, the age of the child, and it should also contain the people who are responsible or the or the name of the occupier, the person who is responsible for actual management, or person who is responsible for the actual management of the establishment. Looking at the provisions that are required for compulsory maintenance of records, every establishment, every occupier is required to compulsorily maintain records, details about the child, the name of the child, the date of birth of the child, the age of the child, and the nature of work that has been allocated to the child. All these are records that should be compulsorily maintained by every establishment which is employing a child. Besides this, there is a compulsory provision which says that every railway, every port, or every other such establishment has been notified must compulsorily display provisions of Section 3 and Section 14, which talks of penalties, when they employ a child, which means in every railway station where a child is employed, a display of the abstract of provisions of Section 3 and Section 14 is mandatory. Similarly, in every port within permissible limits where a child has been employed, display of abstract of provisions of Section 3 and Section 14 is mandatory. So this is one of the important sections, and this abstract must be made in must be displayed in one local language and in an English language, and it is mandatory that these establishments, if they employ a child, should have a display of the abstracts of Section 3 and Section 14. Moving on to the last part of this act, the penalties. So we've looked at why there has been a necessity for enacting or bringing into force the Child Labour Act. We've looked at the important definitions, we've looked at the important provisions, now we've looked at the regulatory conditions, we've seen the various rulings given by the Supreme Courts. Now let's move on to the last part, which says, in case these provisions are not adhered to, what are the consequences, what are the penalties that establishments and occupiers need to face if they do not adhere to the provisions of the Act. So whoever employs any child and contravenes provisions of Section 3 of the Act will be liable to imprisonment for a period of 3 months, which may extend up to 1 year, and they will also be subject to a fine of Rs 10,000, which may extend up to 20,000. In case a person has contravened the provisions of Section 3 of the Act and has repeated this offence one more time, continuing offence, that is, they continue to commit this offence on a second instance, then they will be subject to imprisonment, which may extend for a period of 6 months to 2 years, and they will be subject, or they will be liable to pay a fine which may extend from Rs 10,000 to 20,000. In case there are only minor contraventions in the provisions, for example, an occupier has not maintained records, he has not sent a notice to the employer, has not displayed abstracts of Section 3 or Section 14 as has been stipulated by the Act. These are all minor offences. In case of minor offences, as on a case-to-case basis, the Act stipulates that the penalty will extend to imprisonment for a term of 1 month. So we can conclude and say that a child is meant to learn and not to earn. Let us not deny the privileges and the rights of children. Let us stand by the Act and not employ children. Let us respect the Constitution, where it says that a male member or an adult member of the child which has been withdrawn from employment should be given employment. So let us keep this in perspective and look at the world data. Adding some perspective to all the data that we have seen, to all the provisions that we've seen so far, let us have a quick look at the Child Labour Index map as has been framed in the year 2014. World data shows that there has been gross employment of children in all kinds of factories, establishments, not only in India but the world over. By looking at the legend, children have been employed in extreme risk occupations and extreme risk professions and extreme risk processes in almost all countries of the world, except maybe in the United States, in Australia, and in the Mediterranean countries. And the concentration of child labor has been very high in the developing countries in comparison to the most developed countries. So our process has been easy. Let's recap. We started off by looking at the provisions of the Child Labour Prohibition and Regulation Act of 1986. Our learning objectives included trying to understand the reasons why this act has been in place and the legal framework that this act has offered us. We've also gone on into looking at the major definitions as given by the Act. Then we went on to see the major provisions that have been stipulated by the Act. We looked at a few Supreme Court rulings to see what is the real life scenario. Child labor is a reality, it has hit us hard. And we also tried to find out what the Act has done, and in case there is a contravention in the provisions of the Act, we've looked at the penalties that have been imposed on occupiers and establishments for not complying with the provisions of the Act. So thank you for this, for your patient listening. Hope to see you in the next session.